All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present. We're here. Chastain Esslinger. For the record, state CR 2304. Russell Wayne Ruby. Mr. Ruby was set on Tuesday. I reset. We speak with Mr. White. I reset Thursday. We realized yesterday that Mr. Ruby, I had recused on that case on his underlying original charge on a motion to revoke. We transferred it back to the county court.
Yes, sir.
I wasn't sure if you were aware.
Thank you.
And of course, excuse his appearance today. He's already got a date with the county court, which I believe is November 8th at 10:30. You want to pass it on? You can pass. Zanitra Porter. Here. William Goldner. Here. Jamie Danforth. Jamie Danforth. Joshua Chanel. Here. Sean Davis. Here. John Johnson. Here. Ginger Malkovich. Here. Did I say that right? Malco. Okay. I'll try better next time. Andrea Pullings. Patrick Rowe. Eric Sperling. Tyler Tadlock. Brett Thomas. Janice Spino. Is there anyone who's in the courtroom I've not called your name? All right, Tyler, anyone that's ready? Your wife ready? Mr. Spino. All right, this is a cause number CR 21-113, 114, 15. Drop the call. Let's see, Mr. Spino, I think you last reported pretrial release in July. That's probably the last time we had you report. Is that correct?
Yes, Your Honor.
Okay, I want to make sure that you report and do pretrial release today before you leave. And fortunately, reset you for an additional docket call. Why did Johnson available? Yes, I do.
I'm pretty sure I don't have anything set already in January. If I could have it on a Thursday, I would prefer it.
I'll tell you what, let's do this. Let's try December. What about December 12 or 14?
Let's 14th sounds good.
14th? Okay, Mr. Spino ordered back Thursday, December 14th at 9 a.m. But I want you to check in with pretrial release before you go, okay?
Your Honor, I believe that's all I have today.
Thank you, Mr. White. Biggs, are you ready? Zanitra Porter. CR 1964. All right, Mr. Biggs.
Your Honor, I was recently retained on this case. It's a revocation. Most of the allegations are technical. My staff is working with Ms. Porter to try to help her become compliant. Would inform the court that right around the time that she was placed on probation, she was a pretty serious motor vehicle accident. I think that the accident itself has contributed to some of the deficiencies in terms of some of her conditions. But like I said, my staff has been working since she hired us a couple of weeks ago, trying to get her back into compliance. I'm confident that within a month, we can have community service caught up and all her fees paid off. If the court would indulge us and give us that much time.
Any objection from the state?
None, Your Honor.
All right, we're just gonna reset this order. Let's go, do November 7th, 9th, 28th. Seventh, 9th.
Can we do the 28th just to give me?
You're available for it, so this order then for status on the motion vote. They November 28th, 9th.
I still need to get this filled out, turned in. I'll get them sign off, okay?
Sir, how are you? Morning, man. Like guilty people, people like this.
Good morning.
What are you? You know, it's all- you know you're. Good, Ed, are you ready?
We're just waiting for plea pack, we anticipate having this resolved.
Yes, sir, thank you. Mr. Essinger. All right, this is a sanctions court hearing, CR 19-217. Let's see, Mr. Essinger, really community service is what they're concerned about. What I'd like to do, and I want you to tell me if you can do this or not. I would like to, order you to do, work the first Monday weekend. You get 50 hours from that, that's Thursday through Sunday.
Yes, sir. I did that last time, like you asked. Got that knocked out for you. But like I said, I plan on doing all the first Mondays.
Okay.
Get knocked out.
Well, let's do this. You're delinquent about 60 hours of community service from being on track. You only have 170 total, 50, so you have 120 to go. How about this? If you work the next first Monday, get all that done, if they report back to me that you've done that, you get caught up. I'll tell you what, then I'll let you out of sanctions. So you can have them come back, and you just keep on staying on track, doing what you're supposed to do, and you can expire on time.
Yes, sir. That'll work.
This is what I'm gonna do. I'm gonna reset you for November. Doesn't matter, is there a day of the week that's better between the Tuesday and the Thursday?
Probably. Just depends on if I'm back at the rig at the time. So I'll be going.
You have your calendar, do you know like when you're gonna be at the rig?
So right now, the schedule is there is no days off because we're short-handed. So when I do go back there, there's no set schedule. I can be gone for 3 weeks, 4 weeks. There's no clue, but I can. Time, so preferably that Thursday probably work best.
Well, I'll tell you what, if you get your community service done and you're at the rig, you have Wi-Fi out there to get it. So, and what I probably do is allow you to check in via Zoom. I'll check in with you that day, like community service processed in, and I can cut you loose. Okay, so close to this, I'll set you towards the end of the month. I'll do November 28th. 9 AM, and if you are back on the rig, what I want you to do is contact your probation officer, and let them know. And I will make a note on here that you can check in via Zoom. Okay, yes, sir. If you're not on the rig, I want to see you here though, okay? Yes, sir. You were working the rest of the day doing community service, what all did you do?
I was with garbage people, I was with Javier.
All right, Mr. Weston, you're sign this, you copy this back. Or that's the first weekend, first is gonna be the second, third.
Second, third.
Okay, it's gonna be November 2nd, 3rd, and 4th. In bid, which will be that first full weekend in November 2nd, where, what's the second time period?
Thursday to Sunday.
Thursday to Sunday.
Yes, sir.
I will see you back in November. recess for 20 minutes or so until we get paperwork ready from Mr. Pitt or Mr. Manning's ready. I'll just let you know if you don't want to work.
Thank you.
Yeah, yes.
Your Honor, do you want to sit or?
About next one. Right, I think all the fill out is admonishments and the certificate of the bill. This time case. Already at the level of the. The concept of all the people that you sit right there on that side instead of mine. Yes, please. Mr. Collins. This is cause number CR 23-77, state of Texas versus Fred Thomas III. All right, Mr. Thomas, it appears that the state has filed a motion to dismiss your case. I'm assuming there's no objection. You, Mr. Manning, or you, Mr. Thomas? All right, court, reviewing the motion finds that the state's, request for the dismissal due to insufficient evidence and in the interest of justice, with the by grants the state's motion to dismiss. All right, Mr. Thomas, you are free to go. If you want a copy of this for your records, hang out in the hallway and we'll read it, okay? Be ready on this.
Judge ready on Mr. Joshua Chenault.
Mr. Chenault, come forward, please. This is cause number CR 23-8, state versus Joshua Lee Chenault on docket which.
Yes, Judge. Today we received a new offer that was not previously had not previously been discussed or made. My client would like some time to consider that, and we request to be set for a final docket call for next day or has available.
Mr. Harwell, is the state making additional offers, or is this the final offer being made by the state?
Your Honor, I believe this is the final offer, but
How long do you need?
Judge, if we can just set it out a month, I think that should be sufficient for him to consider the offer.
Is it a probation offer, a time offer?
Judge, it is a probation offer.
We need to set it out a month, set it on. Let's see, maybe for 9. I guess that's close to a month.
Judge, that'll be fine.
November 9th. All right, Mr. Schnall, fortunately, order you back. Another document call on November 9th at 9. Mr. Schnall, you checked in with pre-trial release, confident about your delinquencies, efficiencies. Are you making a payment today, or how are you going to take care of that? How about, right, listen, I'm gonna tell you that inability or failure to comply with pre-trial release is a great indicator as to whether or not you can comply with probation. Right? You can't get through pre-trial release, you'll never get through probation. Okay, so in order for you to approve a probation leave, Mr. Manning is working on that for you. Give that a lot of consideration while we've got your pain, your delinquent, your test positive, everything like that. I may not even approve a probation leave. Okay, so I'm paying attention to what you're doing. I will see you back on the 9 at 9.
Judge, next ready on Mr. Sean Davis.
Mr. Davis. CR 23-95, pre-trial votes me.
Yes, Judge, we have requested specific discovery from investigator Keltner. My understanding as of yesterday was that investigator Keltner had still not completed that discovery. And so we are still waiting that request to be set out for additional time period.
Yeah, David, say.
I don't have them yet, Your Honor. If you like, I can send an email out, see if we get a response in the next.
What is it that you've asked for? What is it that we're waiting on?
Judge, my client's phone electronics were seized as part of this investigation. And they have not been turned over to defense for exculpatory mitigating evidence.
So it's cell phone analysis,
Yes, Judge.
just one cell phone.
Judge, I believe there might have been multiple cell phones. And that's what we're waiting on as well.
State, do you know,
I don't know the exact progress that's.
you know how many phones there are, what's being searched? If you don't know that much, I wanted to be specific, so next time we come back. If it's 5 phones, I understand how long that takes, it's one phone, so maybe less.
Judge, I believe there was one phone, one iPhone, a possible additional other phone, as well as a laptop, or those are the devices that we know of.
All right, let's reset Mr. Davis to November 9th as well. I understand it may not be done by then, but at least we have a status. Analysis. Once Mr. Davis is done.
Thank you, Judge. Next, ready on John Johnson.
Mr. Johnson, if you'll come forward, CR 2163. Johnson said for arraignment stay on activated.
Yes, Judge. My client and I have gone over his indictment. He understands the charge against him. His name is spelled correctly. He understands the range of punishment. At this time, he's pleading not guilty. Actually, Judge, I'll make a correction. He's pleading innocent. I explained to him the difference between innocence and not guilty for a law. But he is pleading innocent. And I'll enter his plea as not guilty.
All right, the court will find that Mr. John Henry Johnson has waived the federal requirements of arraignment that his name is spelled correctly. Court will enter his plea not guilty into the record. I'll set this time for pre-trial. November 9th, visionary meeting works.
Judge, I believe November 9th would be sufficient.
All right, Mr. Johnson, we'll see you back at pre-trial November 9th at 9 a.m. I show that you are delinquent in your pre-trial supervision fees. Have you paid a payment today?
No.
Okay, then how much are you going to pay today?
I can pay it this one. Okay.
Tell me how much you can pay today.
60.
You can pay 60 today. Or you after you're dismissed here, I want you to go to the probation department and pay $60 towards your delinquency. That's only half of your delinquency. Okay. All right. We'll see you back on November 9th.
Judge, ready on Miss Ginger Malcolm.
Smelko. Smelko, we go call all this. I'm sorry. All right, this is cause number CR 23-60, State versus Ginger, Lorraine Malcolm.
Judge, this is actually Ms. Pullings.
Like you said, you're ready.
I said Ms. Malco, I guess.
Ms. Malcolm, come on up. Ms. Williams, have a seat. Malcolm is set free draw.
Yes, Judge. I've had an opportunity to speak to Ms. Curry this morning. We are still waiting on an offer in this case, as well as we request additional time. We're seeking out some medical records involving the situation, the child situation. Judge, I believe that would be sufficient.
Court says Ms. Malco for additional pretrial on the quicker time. Okay, 9 AM. Ms. Malco, I showed that, she billed a report in July, the pretrial release, delinquent $300. What's going on?
I just seen Stephanie last month. I'm starting a new job on the 17th. I haven't had a job in the last couple of months.
How are you taking care of yourself?
As soon as I get my first paycheck, I'm going to see Stephanie to make payment.
I understand. I'm saying, how have you been able to support yourself in the last?
My mother-in-law is working right now and she has been helping take care of me.
When you start your new job,
Next Tuesday.
did you tell your probation officer, your pretrial release officer?
Yes, I actually reached out to her yesterday because I'm gonna go stop by the office after court today to see her because my next appointment is the 18th and my training starts the 17th. If I go see Stephanie, I will lose that option.
Then I want you to get that job and I want you to start making payments to your obligations. Okay, all right, we're gonna see you back on your 9th.
Judge, now I'm ready on Ms. Pullings.
All right, Ms. Williams. Cause number CR 21-140. Ms. Williams, set for compliance.
Yes, Judge. Ms. Pullings, as far as well aware, was short a significant number of community service hours. The goal we set for her, for this last month-long period was for her to get 30 hours of community service. I'm happy to report that she turned in 33 hours. Both within church has been approved through the probation department, as well as her continued work at Restore Habitat for Humanity. We request an additional setting for her to continue working on that chunk of community services code, and request one additional status to keep working on that.
Let's go out a little bit further, Ms. Pullings. Ms. Pullings, I'm glad to hear that. Glad to hear you getting caught up. About the available December 14th, Mr. Mayor.
Yes, Judge, I believe so.
That'd be the only Thursday I had in December.
Yes, Judge, I am available on the
All right,
first.
Ms. Pullings on December 14th. Status.
Judge, ready next on Mr. Patrick Rowe.
Mr. Rowe. This cause number CR 23-116 and 117. Percent free draw.
Yes, Judge, had requested additional discovery from the DA's office after reviewing the forensic CAC interview on August 17th. I spoke to Ms. Curry again today after being told that was not available, and she re-released some of the stuff that's available and is continuing to review the remainder of that. We request to be set off for additional 60 days, as I have requested this information twice already.
Objection to stay.
No objection.
All right, court will set Mr. Rowe for December 14th. 9 AM. Mr. Rowe, I know you're delinquent. $270 or $270. You'll be able to. Yeah. How much you pay your thing?
I'll pay it all.
Pay it all today, right after the court go over and see your probation officer, control release. Pay that out monthly, so you don't. One, so you do that too. You want more on. Okay, I will see you back on the 14th, go see probation officer.
Ready on Mr. Tyler Tadlock.
Kellogg. CR 23-76 for pretrial.
Judge, we had recent this case one time previously on pre-trial for potential additional cases. As of yesterday, they had still not received the cases. We have not received an offer at this time, so we requested for additional pre-trial, so we can get an offer and discuss that with my client.
Is that the only thing you're waiting for, is offer?
At this time, yes, Judge,
We just go ahead and set the docket call.
that's fine. I would ask if the state does get cases and end up filing those additional cases, that we allow those cases to get caught up and run together as they are similar.
All right, court's gonna set, find that there's no contested pretrial motions, for Mr. Tadlock in this case, or we'll set this matter for docket call on November 9th. 9 AM. Mr. Tadlock can also show that you're doing $260 on pretrial release. Sir, how much are you gonna pay today?
I can't pay anything today, but next week I can pay all of it off.
Okay, then I expect you to have it all paid off next week. I'm gonna have the probation office, just let me know if you do or you don't. Okay. And
Yes, Judge.
right, this is file number CR 22-376, state versus William Corey Goulner, raise your right hand, which oath. Sir, you swear that the testimony you give forward with the truth, the whole truth, nothing but the truth, so help you God. Yes. All right, lawyer. Mr. Goulner, are you a United States citizen? Your reads, writes, and speaks English? Yes. Have you ever been diagnosed with any type of mental condition? Yes. You're represented by your attorney, Mr. Mike Head. Are you pleased with Mr. Head's representation? Yes. Like you had enough time to discuss the case with him, you got all of your legal questions answered, you understand everything you've read and signed and agreed to in this paperwork. Yes, sir. Mr. Head, you believe Mr. Goulner to be competent?
I do, Your Honor, and just for the record, I might note that Mr. Weiner actually appears as his attorney of record, but I've been involved in Mr. Goldner's case since the beginning and I'm here on his behalf.
And you believe him to be competent? You, Mr. Weiner, explained to me consequences of getting plea today.
Yes, sir, Your Honor.
Mr. Goldner, to further what Mr. Head said about Mr. Weiner is also your attorney and has represented you here in court. Are you pleased with Mr. Weiner's representation? Yes. Yes. All right, Mr. Goldner, you were originally indicted with a theft of property between $30,000 and $150,000, a third-degree felony. It appears today that there's a plea agreement wherein the charge would be reduced to a Class 8 misdemeanor offense. Sorry, that it would be a Class 8 misdemeanor offense. Well, it says Class 8 misdemeanor 1234B.
Yes, Your Honor, I think it was originally charged as a third degree, and then proceeding on a state jail and doing a 1240 on the state jail.
And then I think it needs to say state jail 1244B. It either needs to be Class 8 misdemeanor or state jail -1244B.
Yes, Your Honor, I'll,
You agree with it?
I do, Your Honor. Yes, sir.
So if we can just get to the front page of the judgment, we agree to say state jail offense 1244B.
yes, sir.
All right, Mr. Goldner, so the agreement is that the state's going to reduce their charge from a third-degree felony offense to a state jail felony offense. And further, they're going to recommend that prosecution occur under section 1244B of the Texas Penal Code, which means that it would be a conviction or a state jail offense committed, prosecuted under 1244B, a Class 8 misdemeanor, with the recommendation being that you be found guilty, that your punishment be assessed at 2 days confinement in the county jail, with you receiving credit for time served, and a fine of $5,000. Question. Been a moment. 1244B, 1244A is state jail conviction, prosecuted as a Class 8 misdemeanor, punishment wise 0 to 365. 1244B is going to be a Class 8 misdemeanor, max fine of $4,000.
Yes, sir, Your Honor. That's correct.
We could have a $5,000.
We had, I think Mr. Weiner and Ms. Curry actually reached this agreement based on the plea sheet last time that it would be a 1244B with a $5,000 fine.
Am I correct on that, or is it just incarceration is as a?
I think the Class A punishment range would apply, it would be a $0 to a $4,000 fine. Now, I think both parties stipulate and agree that there's not necessarily a limitation on that if he agrees. And he has already tendered the $5,000, which we have prepared to tender to the clerk today. But I think the range of punishment is a Class A misdemeanor range at that point.
My only concern is I'm not sure that, a stipulation wouldn't be employed. It's outside of the statutory range of punishment. Understand what you're saying, and that'd be the easiest thing to do, is to say he agrees to more than statutory range. I just don't know that I can agree to that. I think it would make the sentence void. More so than just fine. So wait, give me a second, you grab my phone, let's review that together. Make sure I'm right, I could be wrong, but make sure it's not just as far as incarceration, but it's fine as well. Sorry, Mr. Gold, have another seat, all right? Give me just a few minutes, we're gonna get this paperwork done, we're gonna get you out of here today, guarantee, okay? All right, let's stand in recess for just a few minutes. All right, Mr. Golden, we're back on the record. All right, so the agreement in here is the state increasing the charter. State jail felony under section 1244B Texas Penal Code. And the recommendation is that you be convicted of that offense, your punishment be assessed in 2 days of confinement in Banting County Jail. You're receiving credit for 2 days time already served. And the maximum fine of $1,000. In addition, you're responsible for prosecuting at $70, reimbursement fees of $35. Now, after all that, then you can figure. Yes, sir. All right, then, Mr. Goldner, I'm going to ask you, how do you plead to theft of property creators $2,500 less than $30,000 as a class A misdemeanor under section 1244B? If you couldn't go through that crime, but you aren't guilty of that crime. Is anyone threatened or suppression? All right, court accepted defendant's plea of guilt. Any objection to the admission of the stipulation of evidence?
No, sir, Your Honor.
Stipulation is admitted and court takes judicial notice of the defendant's traditional. Anything further from the state? From defense?
Only, Your Honor, that I did bring a check and I'd already made it for the 5,000. I'll change it and see if the clerk can accept it that way. If not, I'll represent to the court that I will send a check immediately from my office if they can't take it as changed.
Yes, sir. As an officer of the court, I take that statement at face value that it is.
Yes, thank you, Your Honor.
All right, then based on the evidence before the court finds that there is sufficient evidence to convict Mr. Golden of this offense, or follows the plea agreement, or convicts William Corey Goldner of theft of property, $2,500 with less than $30,000, or approves the prosecution under section 1244B as a class A misdemeanor, court assesses punishment at 2 days confinement in county jail. Issues Mr. Goldner 2 days credit for time already served, versus to pay a $4,000 fine, $270 for the bond, or $35 reimbursement fees. All right, the one we hereby remanded to the custody of the sheriffs, carry out terms and conditions of the sentence. I'm gonna have you come forward and be fingerprinted with Deputy Martinez. Then we'll do copies of the paperwork. Seconds. And I'm gonna just put some, figure out a way to take that check.
That's very valuable. I made the change and initial this, so hopefully it'll be okay.
You'll go get you to copy of that paperwork.
Yes, sir. Well, I don't need a copy. I'll
Still, you want to copy? Yes, right. Have a seat on the hallway, or you want to go to the clerk, take care of that, and then also the chair will bring you a copy of that paperwork.
Thank you, Your Honor.
It's about. We just have it.
All right, this is call number CR 957. State of Texas versus Aaron McLean Spurling. Mr. Spurling, you'll reach your right. Where do you swear that it's just what you do before when you go through the equals through and put the truth stuff you know. Name Aaron McLean Spurling, correct? Mr. Sperling, are you a United States citizen with previous rights and speaks English? Have you ever been diagnosed with a child mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation? Feel like you've had enough time to talk about your case, that you've had all of your legal questions answered, and you understand everything that you've read and signed in your plea agreement. Mr. Manning, do you believe Mr. Sperling will be competent?
Yes, Judge,
You've explained to me the legal consequences of this plea, good say.
I have.
Mr. Sperling, you are charged by indictment with a third-degree felony offense, tampering or fabricating physical evidence. That does carry a range of punishment, or to be convicted and sentenced. Minimum 2 years to a maximum 10 years of prison and a fine if imposed not to exceed $10,000. I see the plea agreement in your case, that you would plead guilty to that crime. In exchange, the state would recommend that you were punishment be assessed at a conviction today with a sentence of 10 years, 10 years imprisonment, Texas Department of Justice. The state also recommending that that sentence be suspended today. You be placed on probation for 10 years. Then you pay a $2,000 fine, $180 restitution. And in doing so, the state also dismissed 2 other cases that are unfiled: a driving while licensed, valid previous conviction, and possession of a controlled substance. Mr. Sperling, is that your understanding of the plea agreement?
Yes.
All right, then understanding the plea agreement and the range of punishment, I'm going to ask you, how do you plead to tampering or fabricating physical evidence? You pleading guilty to that crime because you are guilty of that crime. That's anyone threat or force or pressure you to plead guilty. The court does accept the defendant's plea of guilt, any objections to the stipulation of evidence being admitted.
No objection is offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
Rest and close.
Right, court's reviewing the stipulation. All right, the court finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement in this case. Or convicts Eric Glenn Sperling of tampering or fabricating physical evidence. Or assesses punishment at 10 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence today based on the state's recommendation, places Mr. Sperling on 10 years of immediate supervision. Orders him to pay a $2,000 fine, $180 restitution, $290 court costs. And also orders him to pay reimbursement fees of $605. Court also dismisses under section 1245 of the Texas Penal Code. DA 2021-1491, driving while licensed valid or previous conviction. And also DA 2021-1489, possession of controlled substances. Mr. Sperling, have you got your driver's license figured out yet? How are you going to get around, get to work, so you can support yourself, family, and pay your probation?
My girlfriend takes me to work, and then one of my coworkers, he brings me home. I live like 5 minutes from my job.
I want to say 2 things, Mr. Sperling. One, I want you to understand that probation is not an easy route. Probation can be very arduous, difficult, especially if you're not diligent in taking care of your business. It's a lot easier to go sit in a jail cell or prison cell, do your time and get out. Okay, so you've got a 10-year probationary period. It means you got 10 years of having meaningful life. 10 years of having to follow everybody's conditions. That means no alcohol, no drug, none of these, 10 years is a long time. Okay, any of those violations, bring you back here. Mr. Manning told them, state file a motion to revoke, state put on evidence, at a hearing. The court finds that you violated, I can revoke that probationary period and send you to prison for the 10 years that you've agreed to. So I want you to take it very seriously. Don't be out driving, don't be trying to drive to work, pay probation periods, and commit another offense, driving while lost. Yeah. Second thing I want to say is, I'm assuming that what you flushed at the police department, probably a misdemeanor amount of marijuana.
Yeah, it's typically told me to, how stupid I was about turning and just being a felon. I panicked, because I thought I was gonna get like a, control controlled substance in a correctional facility charge. And I just panicked and made a bad decision.
Well, you may have gotten that too, but
I thought that was a felony as well.
it is,
I didn't know what to do.
it is, well,
That's what I did.
now what you do going forward is you always be honest. A lot of times the consequences are gonna be less. Once we start hanging that web up, and it gets longer and thicker, we get more wrapped up in there, it's hard to get out. Right, so I expect you to go to probation, do what you're supposed to do, be model probationer. And I'll tell you what, the probation officers send me people all the time that have done well. They've taken care of all the community service, they pay everything that they're owed, that they owe. They have no violations. A lot of time I let them off probation.
I'm sure.
I hope that's a care for you. If you do that, then I'm telling you, when these probation officers put that in front of me, and I see someone who's been compliant, I see a lot of people who aren't compliant. It takes me really about less than 3 minutes to read those things. If I see compliance and you're doing things earlier, you get them all finished off, I will not hesitate to let you off probation. Now, the flip side of that is also true.
Yeah.
They send me a motion or vote over here and they say Eric's screwing up. Eric's driving while lost in the ballot. Eric's smoking pot. Eric's doing this. I won't hesitate to file a sign the state motion to revoke. Get a warrant issue, bring it back in here and give you a hearing. If they prove that you violate, hesitate to do my job. Okay, so I just want us to be on the same page and have an understanding. Completely. All right, good. All right, Mr. Spurling, hereby remanded to the probation department so they can carry out terms, conditions of the sentence. Have you come forward, Deputy Martinez here? He's gonna take your fingerprint and these off, and give you more information about what's. All right, I believe that concludes the report this morning. My criminal docket, of course, adjourned, stand in recess until 1 p.m. So that. Yes.